Hello, I'm Naavi of Naavi Academy. Today is 17th December 2024, and I would like to briefly talk about data principal request mechanism, a topic on which I recently addressed a gathering of experts in Bangalore. Now, data access is one of the important rights which is guaranteed by the data protection laws. All laws, including DPDPA and GDPR, provide this as one of the important rights. Now, when a data principal approaches a data fiduciary and asks for knowing how are you processing my personal data, the data fiduciary is expected to provide a summary of how the data is being processed. This is the essential aspect of data subject access right. Now, if an organization needs to put in place the compliance measures to meet this right, at the beginning it appears that it is a very simple process. Somebody sends you an email and you just give him a reply. But actually, this exercising of the data access right could actually be the starting point of a much larger confrontation with the data principle, which can snowball into a major non-compliance inquiry by the Data Protection Board. Hence, this needs to be handled with care. Secondly, this being a very simple process as far as the data principle is concerned, it is amenable to abuse. For example, a person may simply send a email request that I am so and so, and I would like to know whether you are processing my data. If so, give me the details. Now, the question here is the person who is asking for data access request is just sending a speculative query on an organization. And in return, the organization should be in a position to say, yes, I am processing your data. This is how I am processing. Or alternatively, he should be able to say, no, I am not processing your data. Now, if he decides to reply in the negative, then in case the data principal has any information about any earlier encounter with the organization, he can definitely show it as a query and then say that you are telling a lie, which means that his right has been denied and denied through falsehood, and that escalates the possibility of a penalty under the system. So before answering in the negative, the company should be able to make a thorough search of their database and then arrive at the decision. Now, the first problem here for the data fiduciary is to identify who is the person who is making a request and whether he is the same person who has some kind of, say, data given to us for processing. Now, we would have acquired data not only through certain specific provision of data in some web page or something like that. We also would have obtained some data sometimes by scanning the web, which is the publicly made available data. We might have also been given data by a third party. That is, we are talking of this compliance data given by a third party. Or it is possible that this complainant may have multiple email addresses and he would have had some kind of transaction with us with a different email address, and now he is sending it from a specific email address. Now, when I make a search using the email address from which the complaint has come, I may or may not find any match. But let us say I have got the complaint received from, say, jr2024 at protonmail.com. And I have a client by name jr2024 at gmail.com. Now, what should I do? Should I consider that JR 2024 is the ID? And in one case, he has an account with Gmail. In another case, he has an account with ProtonMail. It would be risky to make such assumptions. So you will have to ask the person to identify himself with the same identity with which he might have encountered in the past. Then the responsibility shifts to the complainant to give a specific email ID and say that if you have any information against this email ID, then you have to give that summary. Now, the email ID itself, can it be considered as a foolproof identity? Indian law, that is DPDPA, as far as the prospective customers are concerned, or clients or data principals are concerned, expects the data fiduciary to hold an identified consent from a data principal. And that identification is most ideally be done with the use of a digital signature. So in case I have a consent and it is digitally signed by JR 2024 at protonmail.com, then it will be easy for me to ask him to confirm the request from the same JR 2024 at gmail.com with a digitally signed request, and I will be able to identify the person. But in most cases, this is not perhaps practical. The person may say, I don't have a digital certificate. Or he may say that I have a digital certificate for jr2024 at gmail.com, but not at protonmail.com. But if he says so, then at least you have a confirmation that jr2024 at gmail.com is this person's email address. You can ask him to send a corrected data access request from that particular email. Now, at the other end, if you are having the data in jr2024 at gmail.com and the digital signature is verified, then at least the identity is verified. Then the next question is, how do I summarize all the processing which I am doing, considering jr2024 at gmail.com as the core ID of a person? Now, there's a name attached to this particular email ID. There could be a mobile number attached to this. There could be a PAN number attached to it. There could also be an Aadhaar number attached to it. There may be some information which is being processed on the basis of the email address and, let us say, the physical address. There may be another set of processing which may be happening with the email address and a PAN card or something like that. Now, each would be a different process. Maybe different persons in the organization are handling that. It is contained in different systems. And some of the information could be in unstructured form. It may be contained in the personal laptops of some of my employees. So the information which I'm supposed to provide as a summary is scattered across different resources. And my next challenge is to gather all that under the core ID jr2024 at gmail.com, which is digitally verified with a signature, with a digital signature. Then, of course, once you identify the processes in which this particular person comes in, there may be one process where his email is not there, only his mobile number is there. Now, you have to identify that jr2024 at gmail.com belongs to a person called, let us say, Johnny Roberts. And this Johnny Roberts has a mobile so-and-so. And there is one set of transaction which we have done with him purely using Johnny Roberts' mobile number so-and-so. Now, Johnny Roberts' mobile number so-and-so should be linked to Johnny Roberts' jr2024 at gmail.com. Okay. And then we have to identify both are the personal data associated with Mr. Johnny Roberts, and combine that and give it as in the summary of transactions. So In practice, however, many times the companies will find it difficult to identify this information scattered across different places. And we normally use some kind of technique for discovery of personal data to identify such data and then perhaps combine it to understand who is the person to whom this belongs to. Now, if you have got a jr2024 at gmail.com belonging to Johnny Roberts, and there is another, say, email jr2024 or say jr2025 at gmail.com belonging to, say, J. Rajan. Okay. Now, the company needs to actually distinguish these two as two different persons. So if you are using the core ID as the email ID, then you know these two are different. But suppose the core ID is a PAN card or something, then that will be the distinguishing feature. So the identity of the person, getting the appropriate authenticated request, then finding out where all that particular information is stored, and then collecting it into a summary. These are the activities which are required to be done before you either send the summary, or if you do not find any such information, send the information in the negative. The reason why this kind of a check is required is that after you send the reply, there could be several follow-up queries. First thing the person would say, if you say no, is that no, I have the information, you are wrong. So that is a non-compliance, you are not maintaining the proper details, so I will file a complaint with DPB. Suppose I give the information, then he may come back and say, please erase my information in all the places, one. Or he may raise a query, why are you processing this information in a particular this thing? Please let me know whether I have given you a consent for this. Give me a copy of the consent. So you have to go back and check the consent artifact, which you should have stored and you should have tagged to this particular customer, and then extract it and see whether that consent is a consent for all the processes in which you are using it. Otherwise, you are getting into a trap and you will be answerable for using the data for a purpose for which consent has not been obtained. Now, let us take another hypothetical scenario. This person, jr2024@gmail.com, data exists and you have also replied. Now, somebody writes to you and say that I am the father of jr2024@gmail.com, who is a minor. Now, the question comes then whether handing over the information to jr2024@gmail.com was proper because he was a minor, whether we have not identified him as a minor earlier. Okay, of course, if we had used a digital signature as an identity, perhaps this would be sorted out because digital signature is unlikely to be given to a minor. But if I have not used that and used something else like a metadata for identification or a mobile number only for identification, then I have a problem. Okay, so the possibility is that the data principal can be a minor, then you have to identify the guardian and the request has to be given to the summary has to be given to the guardian after his verification. Similarly, there can also be a request from a person who says, I am the descendant of this jr2024 gmail.com who has expired and I need to have access to the data because I am the legal heir. So then you have to look at your nomination system. So therefore, this one request of data subject access triggers the mechanism which should have been in place for receiving the request, verifying the identity of the requester, and then verifying whether the data of a similar person exists in our organization, collating all the data which may be available, and then preparing the summary. So at the end of it, we should also know that if the request for erasure comes, I should be able to kill all the data wherever it is, and then give him a certificate that no more your data exists in these processes. At that time, there is another verification required whether this data needs to be retained for any specific legal purpose on behalf of the data fiduciary. And if so, I have to retain that as an archive, and also inform the data principal that I have removed the data from all active usage areas. However, we need to retain this for a certain period for some XYZ reason, and we will take action to delete on a later date. So this is how one single, you can say, compliance process extends to multiple requirements, and that is the complication which we have in the DPDPA compliance. Now, to make this possible, the DGPSI, or the Data Governance and Protection Standard of India, has created a foundation system which will enable you to handle these queries in a manner in which the risk of a mistake is the least. See, after all, we are all looking at mitigating the risk. Maybe elimination of the risk is not possible. So we are actually looking at mitigating the risk, and DGPSI is the most relevant framework of compliance which enables you to comply with the DPDPA. Thank you, friends. And in case you have any questions on this, please write it to me. In case you feel that this was informative, please like and share the video also. Thank you.